Afternoon. Can everyone hear me?
Yes, Your Honor.
Yes, Your Honor.
We are here on case number 5D 2024-0989, State of Florida versus Thomas Michael Pastor Jr. And by order dated April 17th, 2025, we set oral argument today. Again, my name is Harvey J. I'll be the presiding judge today. I have the honor, privilege to be joined by Judge Eric Eisnagel and Judge Adrian Soud. As I know both of you probably realize, Zoom is wonderful in so many ways, but it also presents challenges at times. And if you would be kind enough to allow us, when it appears that we are trying to ask a question, to be able to verbalize the question, that would be appreciated. I think I can speak on behalf of all three of us. It is not our intent to disrupt or interrupt, but just the nature of Zoom at times, not knowing what you're going to say until we can actually see it on the screen. Also, for the benefit of the recording, if you would be kind enough to turn off your audio if you're not speaking, that would allow us to avoid any of the ancillary noise that sometimes is picked up by microphones. So that would also be greatly appreciated by the panel. Anything further for the court before we get started?
No, Your Honor.
No, Your Honor.
As the court understands it, this is the state of Florida's appeal. So on behalf of the state of Florida, typically 5 minutes is set aside for rebuttal. Would you like to set aside time for rebuttal?
The 5 minutes would be sufficient, Your Honor.
And for the record, would you be kind enough to announce your appearance?
Yes, Your Honor. May it please the court, my name is Richard Pallas. I represent the state of Florida.
Thank you, Mr. Pallas. So we'll set aside 5 minutes and you may proceed when you're ready.
Yes, Your Honor. The state seeking reversal of the motion granting the order granting the motion to suppress here. The trial court found that it was an unequivocal invocation of the defendant's right to counsel. However, we believe that this was an equivocal kind of matter that happened. Here with this particular case, I believe we're looking more like cases like State v. Carter or Joseph v. State, cited in the state's initial brief.
Mr. Pallas,
yes.
Is there an algorithm for the court as far as the answer to whether a statement is equivocal or unequivocal? Is there a definitive litmus test for that question as far as how to answer it?
Yes, Your Honor. This litmus test is, of course, an objective one. And as at least stated in Davis versus United States, we're looking at a reasonable officer in light of the circumstances would have understood only that the suspect might be invoking his right to counsel. And in those circumstances, we are looking at equivocal or ambiguous statements, and that they would not be called unequivocal if that particular test is met, Your Honor.
And perhaps you've already answered this, Mr. Pallas, in your brief opening remarks. If we were to look to cases to help us answer that question, what cases would you direct us to?
Yes, Your Honor. I know I don't need to recount Davis versus United States here. That's obviously our start all. And then Owen v. State v. Owen, as well as Almeida v. State, being our main Florida Supreme Court cases on this ordeal. But to get into our more specific cases that I think would help this court reach its decision in this matter, that would, of course, reverse and remand with directions for the trial court to deny this. I believe we are looking at cases such as State v. Carter, which was out of this court in 2015, as well as Joseph v. State out of the 4th DCA in 2018. I think those two cases are, while of course all these cases are nuanced, I think those are two very close and on the money cases. I think it's worth noting that the state did supplement with authority from the Smith v. State case, and I thought that a very important line that I noticed from there is that these interactions can be complicated. They're not so simple. And here, I think we're looking at one of these.
Counsel, did in your initial brief, you essentially, as I understood it, made two arguments. First, you argue that the request was equivocal,
Yes,
and then
sure.
you make an alternative argument, right? That even if the request was unequivocal, that then the defendant reinitiated conversation. Is right? Correct? Those are your two arguments.
Yes, Your Honor,
The
that would be
question
our
is,
alternative argument.
is the alternative argument preserved? Did you raise that below?
With our alternative argument below, it was my understanding with reinitiation that a few of all the cases cited, I know Green was focused on by both parties, and I know Green was, of course, on one end, whether it was unequivocal, and then on the other end, whether the detectives were allowed to, how would you say, reinitiate with this defendant. But of course, the law is that defendant must initiate first, unless we're in certain gray areas, of course. I would argue that that would preserve this particular argument on appeal, Your Honor.
Okay.
But to return to that, this was an equivocal and ambiguous statement. I think when reading through what is in this court's opinion in State v. Carter, before the Miranda waiver was even entered, the defendant said, I should talk to my public defender. But at the same time, he said he wants to tell the whole truth. I think that is spot on with what we had here. After the defendant was Mirandized, after talking with law enforcement for approximately 10 minutes, they asked specifically of these Miranda questions. He may choose to answer questions, but he also has the right to stop answering questions at any time and speak to an attorney. He said that he understood those rights. And then with those rights in mind, he said, yeah, when they asked if he was willing to speak to law enforcement then and now. At that point, the defendant stated, after they asked, can you tell me what happened that night? He said, I can, but obviously I know my rights. I do want a lawyer. I will answer questions. I do want to speak with you. And then he proceeded
Counsel,
to.
all of that, it's as I read the transcript, it seemed like a back and forth, right? There was a moment where you think that there's going to be a request for counsel, and then in the very next breath, I'm asking myself, okay, well, what does he want?
Yes, Your Honor.
And I think that the parts of the transcript the trial court identified, there's a strong argument that those were equivocal at best. But there's a part of the transcript that the trial court did not identify that potentially could qualify as a tipsy coachman basis for affirmance. And I also wanted to get your take on that part toward the end of the interrogation, if you will. Detective, do you want to talk to us now without your attorney? Defendant, at this time, I'll go ahead and say no at that case. Detective, okay. Defendant, we'll just wait for the attorney. But can I ask just one question? At what point would an attorney, I know there's no guarantee, but what does that look like? Detective, and he was cut off. Defendant, if I want to get an attorney, how long would I have to wait for one to come here? Or would they come first thing in the morning, or would it take days? No, they won't come. Detective, no, they won't come here. That's what we're trying to tell you, is this is your opportunity to have a conversation. So in that exchange, it seems like had do you agree that had the defendant stopped when the defendant said, at this time, I'll go ahead and say no at that case in response to, do you want to talk to us without an attorney? Do you agree that if the defendant had stopped, that would be an unequivocal request for counsel?
Yes, Your Honor. If read in isolation, that was all that was stated. It appears that should be.
No. If everything before happened, then defendant said, at this time, I'll go ahead and say no at that case, and then didn't say another word. Is that an unequivocal request for counsel?
Your Honor, without another word, I would argue the state would have a much harder argument with saying
I'd argue you'd be in trouble. Right? At that point.
Without the context of the remainder of this interview, Your Honor, I believe there's plenty of statements if we kept them in isolation within this particular.
No, I want to be very clear. I'm not asking you to take that statement in isolation. I'm saying if the entire exchange happened, the entire thing, from beginning to that point, but then defendant says nothing beyond that point. So there's a lot of context. Is that equivocal or not?
Without any of the context that we have afterwards, Your Honor, right. I'd argue that then we're looking at more of an unequivocal statement.
Yeah. But then without really any substantive statement at all from the detective, at least according to the transcript I read, the defendant goes on spontaneously, apparently on his own accord, without any prompting from the detective. We'll just wait for the attorney. But can I ask a question? At what point when an attorney comes, he's once again, as he is numerous times throughout this interrogation, numerous times he's tried to figure this out. He's once again trying to figure out what does this look like? If I ask for an attorney, how long will it take? And he even says, without prompting, if I want to get an attorney, how long will it take? You have what looks like a very unequivocal statement followed then by the, if I want to get an attorney, how long will that take? How do we analyze that?
Your Honor, I believe we analyze that more as the Almeida version of our case laws, which is that we're looking at a prefatory question. Like you said, if that was the only thing that was stated on the prior transcript page at the bottom of page 420, the state's in trouble. But going into the question that he then proceeds to ask them, specifying how does this work, for lack of better terms, on 421, I believe there, Your Honor, we're dealing with whether or not he made a bona fide question about his right to counsel. And then the state needs to make a good faith effort. In that good faith effort to answer that question, as the case law is clear, the state does not need to give advice. The state needs to only be honest and give a common sense answer, if you will, from the detectives, based on the case law.
So is it your position that that the proper way to look at what the defendant was saying here and the way the detectives would have reasonably interpreted is that we have to consider his entire statement, which was at least the unprompted part, the part that was entirely him. And even though the initial sort of part of it sounds like it's an unequivocal request for counsel, then the second half sounds like the opposite. And you would say we have to consider that essentially one statement.
Yes, Your Honor.
Okay.
We can't view that in isolation. And I would also argue that we should almost view this statement in tandem with the very first statement that was made after they asked, can you tell me what happened that night? Because that was, of course, one where he stated, I can tell you. And then he proceeded to mention an attorney. And then he moved into telling them what happened that particular time.
Yeah, in other words, you're saying it wouldn't have been a surprise to these detectives that he was bouncing back and forth between, well, gee, do I want an attorney? And hey, let me ask some questions and talk to you. Right?
Yes, Your Honor. And this is, of course, two detectives who had at least been speaking to the defendant for approximately 10 minutes. Before this interview turned Mirandized. And of course, we found ourselves in the posture that we currently are in.
I'll ask your opposing counsel this same question, and I don't expect for your opposing counsel to agree that either analysis actually applies. I expect as your brief says, you're going to say they both apply. I'm going to ask you which one is the better analysis. How does this case fit better into the, is this an equivocal request or not? Or does it fit better with the analysis, the alternative argument you made in your initial brief, which is that it's an unequivocal request followed by a reinitiation of the discussion by the defendant, unprompted, importantly, by the detectives. Which analysis do you think is the better fit?
Your Honor, it falls pretty well into both of them, but of course the state would go with its first argument here, that it falls into the equivocal statement portion of these arguments. I think that this is more of contemplative behavior in the Joseph v. State case from the 4th DCA, where he is saying things one way and then proceeding to say something else. So I would argue that this falls into equivocal, but if this court was unconvinced of that, I believe it fits on all fours within the reinitiation section of cases here. The fact of the matter is after he stated that sentence, there was no statements of, you need to talk to us. It was just, okay. And he proceeded to ask this question, which
well,
of course...
if the officers believed that his request for, or the invocation of his rights were equivocal or ambiguous, the Constitution permits them to seek clarification, does it not?
Yes, Your Honor.
They don't have to sit there mute. I mean, they're entitled to get an understanding of what the defendant wished to do, and it seems to me that's what they did.
Yes, Your Honor. That is exactly what law enforcement did here. And in fact, the dictates of Davis versus United States stated that while this would be better practice, they weren't necessarily holding law enforcement's feet to the fire to do this in every single circumstance where it is equivocal. Here, law enforcement's going above and beyond here, making sure the defendant knows that he's waiving his rights.
Counsel, can I ask you about Laurito? I'm sorry.
No, go ahead. Go ahead.
Can I ask you about Laurito, which is I don't know if I'm saying that case name right, but it's cited by I think it's the trial court cited it.
Yes, Your Honor, a 5th DCA case out of the 20.
Where this court said, do you think this court's sort of statement there that we can't consider anything after the unequivocal statement, do you think that's an accurate interpretation of Laurito? And I just would point out that we cited Smith, the U.S. Supreme Court case.
Yes, Your Honor. I believe Laurito's a little different here because this was that, can I make a phone call so I can get a lawyer? That was, I think, in response to when he was having his Miranda rights read. We hadn't been post-Miranda, I want to say, in that case. I don't want to misrepresent facts of that, but if I'm remembering that one correctly, he asked, can I make a phone call so I can get a lawyer? It was when that portion of the Miranda rights were read, Your Honor. And of course, we certainly have plenty of decisions talking about that. We must look at this objectively. We must look at the context of this full entire interaction here. And I would argue that all of that plays into here. Now, if this court, again, I just want to return to a earlier question we had about if this case fell into the reinitiation cases. The defendant was the one that initiated here, and under the totality of the circumstances, he waived because they went back and forth with their questions. They gave good faith responses. They said, we have to stop if this is what we're going to do. And he ultimately said, I'll talk to you. I will. Yes. And so I would argue that if this case was under the state's alternative argument, we both have the defendant reinitiating this encounter immediately, and we also have a knowing waiver of his Miranda right to counsel at that point. But of course, the state's going to argue that we have equivocal here based on the case law that we have within our brief and viewing not just this transcript in its totality, but also just listening to the audio and being able to see that sometimes there's crosstalk, how quickly the defendant goes from saying something one way to going the other. If I remember correctly in my timestamps, if you count from the second that he first goes into the interview room, at this time, I'll go ahead and say no, was at the 16-minute and 24-second mark. By the time he says, can I ask one question? It's at the 16-minute and 31-second mark. That's different than what is referenced in the motion to suppress, and I believe the order. I was viewing the full, I think, 50-ish minute of the interviews there, but that is part of the state's exhibit number 5 that was provided to this court and was, of course, accepted into evidence. but I see that I am eating into my rebuttal time here, so I'll reserve the rest of my time for rebuttal unless this court has any other questions.
Thank you, Mr. Pallas. On behalf of Mr. Pastor.
Yeah, may it please the court, Attorney Jeff Golub on behalf of Mr. Pastor.
Thank you, Mr. Golub. You may proceed.
Thank you. I believe that we have an unequivocal invocation when he says yes, but also yes to the lawyer if I can have one. And I think you can't look at these things in isolation. You have to look at it from the beginning. As I put in my brief, he's saying that he wants to have a lawyer present while he speaks. I think that's very clear. At first, I can see that they're not sure because he says, you know, I want a lawyer, but then he continues to speak about what happened. But then as you go on, they say, so are you saying that you do agree to talk to us? Yes, but also yes to the lawyer if I can have one. And he can have one. He's allowed to have one. And I believe that if you're going to say you have the right to have a lawyer present during questioning, then you shouldn't even be allowed to say, well, you really don't. We don't mean it. These rights mean nothing, because it's hollow to tell someone they have a right to have a lawyer present during questioning. And when they say they want a lawyer present, no, you can't.
Do they have a
We're
right
not
to
gonna-
questioning? Counsel, do they have a right to questioning? Where's that in the Constitution?
Which one? I'm sorry, the lawyer, do the police have a right to question?
No. Does your client have a right to be questioned? And if so, just point it
Yes,
out in the
he has a right-
Constitution.
I'm sorry, he has a right to be questioned.
He
Yes.
does?
Well, not if he invokes his right for a lawyer, then he doesn't.
Right. I mean, I guess you were saying that you don't think the officers, well, maybe I misunderstood your argument. You don't like the fact that the officers essentially said, hey, if you want to, if you don't want to talk to us, we're going to shut it down. I think is the words they used. We're going to stop.
I guess what I'm saying, no, I didn't say stop. Here's what I'll try to make it clear. I'm sorry. What I'm saying is when you tell someone you have a right to have a lawyer present during questioning, and he says he wants a lawyer present during questioning, then I believe that they should either stop questioning at that point or they should provide him a chance to get a lawyer. That's when you could offer him
Yeah,
a
if it's an unequivocal request, then they would need to stop, right? I mean,
Yeah.
essentially, but that's clear, right? There's a legion of cases saying that, right?
but
I
something
think the question though is what was there an unequivocal request? And the statement you point to, to me, I'll just be honest with you, to me, it seemed I wasn't clear on what he was asking for. And it's a painful transcript to read because, throughout the entire thing, you're trying to figure out what exactly does he want? What exactly is he asking for? And the officers continually try to get him to clarify. But it was lost on me through most of the transcript what he wanted.
Well, and I understand that because as I'm reading that, you want him as a defense attorney, you want him to stop at every time, and then he does continue. But what he continues to talk about, and I don't, we're talking about reinitiation. I believe when you talk about reinitiation, you're talking about reinitiation to tell what happened, to perhaps confess or give your side. All he's reinitiating is when he can have a lawyer. Can I have a lawyer? When can I have it? Are you going to give me a lawyer? What time? The only thing they say is it'll get appointed to you sometime. I think
Let me probe that point just a minute, though, Mr. Golub, if I can, because to reinitiate necessarily presupposes an unequivocal invocation of right to counsel. Do you agree with that?
Yeah.
Absent that unequivocal invocation of right to counsel, there is no reinitiation because there's been no stopping of questioning. You would agree with that?
yes.
So this is what I've kind of, and I watched the video. I watched, and maybe it's just this constitutional odyssey, let's call it, spans more than 5 minutes. It spans almost 6 minutes. I have my notes beginning at about the 12-minute mark into the video. Do you wish to speak to us? Yeah, I want a lawyer. I do want to speak to you. He tags both sides of the coin very rapidly about the 12-minute mark. And there's considerable give and take, conversational, some question. The one detective, I think it may have been Shedrick, trying as he might to get clarification on what it is he's invoking. And they say to him, look, your rights are important. We don't want to violate your rights. They demonstrate that because in 43 minutes into the video, much after he's spoken for 26 minutes. At 43 minutes, he says, I think it's best now not to answer questions without a lawyer. And they fold up shop and they're gone. They're done. They're not going to ask any more questions because at that point, he unequivocally said, I want to talk to a lawyer before I answer any more questions. But I'm curious what you do if we start at 12 minutes, at 17 minutes, 24 seconds into the video. He makes the following statement. When the detectives are trying to get clarification, he makes the following statement, and I quote, I'll talk to you right now without an attorney. And I would like to know what you do with that when the argument is earlier in this conversation, 12, 13, 14 minutes in, he says, I want a lawyer, but I'm willing to talk to you. Let me ask some questions. And then once his questions have been answered and the detective is seeking clarification, you'll talk to us without a lawyer. I'll talk to you right now without an attorney. Does that end the analysis for us?
Well, I mean, I guess the way I look at that is they're interrogating him at that point. I mean, they're specifically saying, well, then you leave us to make our assumptions. And then they say, we've talked to, your mother, we've talked to your cousin. At that point, they're interrogating him. They're going through. So now, yeah, he confesses. Now he's been told pretty much he's never going to get a lawyer. We're not going to get you a lawyer. And now they're no longer clarifying. To me, I mean, the case law says you have to ask simple questions. Even if it's an equivocal request for a lawyer, they have to ask specific questions, harmless questions to see, what he wants a lawyer. They're not.
In other words, the questions are intended to gain the clarification. They're permitted to ask questions as to whether or not he's invoking his right to counsel and really not go beyond that, right?
Right.
And in your estimation, do they do that from 12 minutes to 17 minutes, 24 seconds until he ends the discussion with, I'll talk to you right now without an attorney?
Well, I guess we got to look at what he says right before, which is going in. At this time, I'll go ahead and say no at that case. And then I agree. He goes, well, I'll just wait for an attorney. So now he says, I'm going to wait for that attorney. But
Right.
Can I ask one question? When am I going to get that attorney? Like, if I want to get them, how long? It's very clear he wants it to me. It's very clear he wants this lawyer to be present while he talks. I mean, he does want to speak to him, but he also wants that lawyer present. And that's when, again, Detective Bogus says, no, we're not going to come here. So that's what we're trying to tell you. This is your opportunity to have, a conversation. He says, yeah, about what occurred, to hear your side of the story. They're no longer clarifying anymore. They're now trying to get him to confess. He even says, if you want a lawyer, right, you say, we're going to stop. We've got to stop. Your rights are important. Yeah. And you're going to go back there and ultimately leave us to make assumptions. This, again, is not trying to clarify if he wants a lawyer present during. They're now saying our assumption, because we already talked to people, and those people, and this is just like the Green case. In the Green case, they go on to interrogate. I'll agree in Green, he's more clear, but that doesn't take away from my client being clear. He says, I want a lawyer during questioning, present during questioning, which is what I'm saying. My client is saying here, yet in Green, they just go on to interrogate, just like they do here at this point, because you're asking at this point in time, they do not keep clarifying. They now are basically trying to get him to confess. You leave us to make assumption. We've talked to your mom. We've talked to Sarah, Rhode Island, Venus. These are questions that are likely to elicit an incriminating statement, and they do. And that's why he says, okay, right now I'll talk without that attorney, which is very similar to Green, which he says, I want the lawyer present now. And they said, yeah, you can have it at any time during question. You can do so. I'd like to have an
Counsel,
attorney.
that sounds like a pretty unequivocal request that you just told us there, right?
Yeah,
What was
you're right. I like to have
There's
an
no
attorney.
question about that one, right?
No, but
How was your client's request? And look, I get that that there's got to be some real pressure when you're being interrogated by law enforcement. I have no doubt. But how is this not equivocal when he says, "Yeah, I want a lawyer," but hey, wait a minute. Well, if I get a lawyer, how long is it going to take?
okay, so they need to clarify that and answer that.
I mean, how many times do they have to clarify? I mean, do you at least agree that it's a painful transcript to read because they how many times did they attempt to get clarification on this very point? Do you have any idea?
Well, it was painful.
It's a lot, right? Over and over, right?
Yes, but that still doesn't stop the fact that they have to clarify. Look, in my opinion, this is a simple way to clarify it. They just give him a chance to call an attorney. I mean, he says, I want an attorney present.
No, that's, I mean, what case requires that? I just,
Well, I'll look at UNRRA from just a blood test. If you can do it in an unconstitutional thing where they say, if you ask for a breath test, then you can ask, this was from the 5th, and UNRRA was the Supreme Court, where they said you should at least give the person a phone book if he wants to get a blood test. This is a constitutional right, the 5th Amendment, the right to remain silent. Here's the thing, if they're going to read rights that they read, whether you agree with that as being part of the Constitution or ever, we've accepted the fact that you have to read someone their rights. Prophylactic, we've said that. And in those rights, we say you're allowed to have an attorney present during questioning. And that's the whole thing here. He's not saying he doesn't want to talk to him. He does, but he wants the lawyer present during questioning. And he's asking, when am I going to have a lawyer? When are you going to give me a lawyer? The only thing they ever say is we're not going
the
to.
counsel, he clearly cared about the timing. Do you agree with that?
Yes.
How many times did your client during that transcript ask about the timing?
I don't count how many times, but he certainly does it a lot of times.
A lot, right? He very much cared about the timing, right? So it's I don't know why should these officers, when sort of they're in that conversation, why should they assume that the timing doesn't matter to him? He's made it clear the timing matters to him. And if the timing matters to him, it's not like he said, hey, I don't care how long it's going to take, I want a lawyer present.
Well, at one point, I mean, he says, is it going to take days or is it here's the answer. You're going to get a lawyer tomorrow morning. That's when you're going to see.
No, they don't. I mean, how do you know that they even knew that, right? I mean, there's no requirement that the lawyer be there tomorrow morning.
Well, when you go in front of a judge at first appearance, there's lawyers.
I don't know. I mean, how look, they don't know when he's getting a lawyer, right? And there's no requirement that they do know.
Well, they say, well, but they can't go on and tell them you'll get one appointed sometime. You see, they decide to engage in that conversation. Here's what they say. You're not going to have one now. We're not going to get one, and you'll get one appointed sometime. My point is, if they're going to clarify what he's asking, to me, it's clear in the totality of the circumstances and the case by case in this case that he is saying he wants a lawyer present during questioning. And they keep asking him compound questions. They can't.
Look, I understand. And look, the arguments you're making are not unfair arguments. Okay. Right. This is maybe perhaps arguably a somewhat of a close case one way or the other, but is it possible? Is it unreasonable if the detectives were interpreting your client's answers and statements in this interrogation? Would it be reasonable for the officers to think that, well, he might want to talk to us if the lawyer isn't coming right now, but if the lawyer's coming right now, he wants to wait for the lawyer? Is that an absurd possibility, or do you think a person could actually view it that way, right? Like, gee, if I have to wait days for a lawyer, I'll just go ahead and talk because that's my choice. That's what I want to do. Versus if they're 5 minutes away, I'll wait. Don't we make those decisions in life all the time?
He never says that. I mean, he's asking a question. They need to answer. They need to simple clarification. Daniel says that out of the film.
Come on, I think he made it very clear that seems to be the analysis that was going through his head, right? If I wait for a lawyer, how long am I waiting?
I think what he's asking is, when am I going to get a lawyer? Because I want one present while I speak. I'm not going to speak to you without a lawyer present. And he never says he will. In fact, when they finally ask him a complete question, he says, no, I'm not going to speak to you without a lawyer present. But yes, then he continues to ask at that point, when are you going to give me a lawyer? And I think, again, at that point, I guess what I'd like to understand is, what's the point of telling someone you have a right to have a lawyer present during questioning, but you really don't, because we're not going to give you one? I mean, how is that even allowed to be an answer?
Did they say they said they weren't going to give him one, or what?
They said, we're not going to get one now. We're not going to bring you a lawyer. You're not going to.
Not right now.
Make a phone call to get a lawyer now and ask and find out, why is that so hard? If they're gonna clarify his questions, they shouldn't be able to say, it's one or the other. They shouldn't be able to say, we're not bringing you one now. I mean, why? Then why tell him we can have one now? I mean, don't you see that? That doesn't make sense.
When did they tell him that he could have one now? When did they say that?
No, they never say, that's my point. They never say you can have one now. They say you can't have one. We're not going to bring you a lawyer now. Never do they say they're going to give them one now. They clearly say, we're not going to have a lawyer now. We're not. They tell
So
them.
is it your argument that detectives are required to have a lawyer on call?
I was figuring you would ask that question. No, I don't think some lawyer necessarily could just pop out of nowhere. I would note that the public defender's office, because I had a beeper when I did it, and you can call and talk to a lawyer if you want. But what I do believe is that they should allow him, nowadays they don't have phone books, but they should allow him to make a call. Yes.
And his right to counsel does not obligate him to have counsel present. You would agree with that too, right?
Well, but it does, because they say the right, you have a right to have a lawyer present. So we say that's just a trick, it's a lie. I mean, that's the Miranda rights. You have the right to have a lawyer.
So is it your position that the Constitution of the United States obligates a defendant or suspect to have a lawyer present when he's being interviewed by law enforcement?
If he wants one present during questioning,
That's
yes.
not my question. My question is, does it obligate him, the accused or the suspect, to have a lawyer present, or is he free to proceed without a lawyer present?
Well, he can always be free to go without one, but my point is he's asking to have one present during questioning.
Well, and to Judge Eisnagel's very good questions, it seems to me he's kind of weighing the scales just a little bit. How much time is this going to take? Am I going to be in here for days? Is it going to be tomorrow morning? Those sorts of things that he may be taking or including in his calculus to determine how he wishes to proceed.
I guess I don't see that. I see that he does want to know when. He clearly says, even at one point, he goes, I'll wait for the attorney. But yeah, he would like an answer.
The counsel, I mean, look, look, I think that your argument would be a little bit stronger, maybe quite a bit stronger, if he didn't say, like, if I want to get an attorney, how long would I have to wait for one to come here? First thing in the morning, or would it take days? He didn't say, hey, I want an attorney. Also, by the way, when will he or she be here? Didn't say that. He said, hey, I want an attorney. Well, if I want to get an attorney, how long will it take? I just, it's hard to understand how it's unreasonable to interpret that as sort of
here's my
equivocation.
Here's my answer. Let's say that I'm denying. Let's say it's equivocal. It's an equivocal asking about his right to an attorney. In other words, if I want one, when is one going to come? And here's their answer. They won't come here. I don't think that's after you told him he could have one. Now we're telling him, no, you can't have one. I guess I don't see how we get past that. Why read the Miranda rights to say you have a right to have an attorney present? But then when he says, okay, so when's it going to come so I can talk? Earlier he said, right before that, well, we'll just wait for an attorney. But can I ask one question? He never says, well, I do want to talk if a lawyer is never coming. To me, he's basically saying, tell me, when will the lawyer come? Answer my question. And it's a simple question that they need to answer, as Daniel says, and the other case says, when you're asking just equivocally even about whether you can have a lawyer, they have to give straightforward answers and simple answers. Their answer, though, is, well, even though we told you could have one present during questioning, you can't. They won't come here. My point is,
That's not what they said. They said that he won't come here now. I mean, can questioning take place elsewhere at a different time? Is that possible?
well, they pretty much tell them no, though. See,
Well, and then my other question is why does the Constitution require law enforcement to question a suspect? Why can't law enforcement just say, we don't want to talk to you?
you're right. They could say we don't want
Yes,
to.
I am right.
Yes, you're right.
So
But
why?
But they don't make that clear either. They don't make that clear. They keep saying, well, we won't talk to you now. And then, ultimately, because you can't have a lawyer now.
Well, they did say this is your opportunity to have a conversation. Why, I mean, why isn't that saying, hey, we're not going to talk to you later? And they don't have to, right? So
They don't, but if he asks to have, but if he's allowed to have one present, you're right. They can just say, well, we're not going to question you. But they didn't do that. They didn't just say, we're not going to question you and stop. And I don't think that he reinitiated that after that. After he says, yes, I want a lawyer and I want one present. And I do think it's clear enough to know. I think they're purposely trying to say, oh, we don't know. And I agree in the beginning they wouldn't. But if you read it all the way up to the point where he says, yes, but I also want
Before your time expires, I do want to get one clarification from you. Do you think this spot in the transcript that I've identified where he says, at this time, I'll go ahead and say no at that case, and then proceeds for a couple paragraphs. Do you think is that the most important part of the interrogation, or would you say it's earlier? Just give me a short answer.
Yeah, sure. Well, I think it's earlier when he says yes to both, but if we're going on with it, I think that is the second most important part, because that, and I would quickly bring up the Belt case where that's what they say. He says, so if you're wanting an attorney, we'll have to stop now. Okay, which they really never quite say that here. And then they say, all right, so you want an attorney present with you? And he says, I think we can go on. And along the way, when he's finally asked that question, not a compound question that you can actually understand, because I thought it was difficult to understand the police's question, he says, at this time, I'll go ahead and say no. And the rest of his questions are just, when is that lawyer going to come that I want? Because I'm not going to talk to you unless I have that lawyer. Thank you.
Thank you, Mr. Golub. Mr. Pallas?
Thank you, Your Honor. I have 3 points for rebuttal I'll try to get to here. I know I ate in a little bit of my time. As to this section of the transcript on page 417 about yes, but also yes to a lawyer, I think that is just the same as the situation of if you ask someone, do you want to go get lunch or do you want to see a movie? And they say yes, and they don't proceed to answer your disjunctive. I think that going off of, for my second point, where he stated right now without an attorney on page 422, I think we take these statements like yes, but also yes, but view it in the full context of where he goes from there. On this same page, 417, after they ask him, do you want the lawyer later? Do you want the lawyer? We're not bringing him in here now. He proceeds to, throw up his hands. No, I don't think so. No, no, no. He repeats saying no multiple times on page 420. To another clarification from law enforcement. And he, of course, says after right now without an attorney, I should have been clearer. So playing all that in here, it looks like he's just wondering when he would be able to get an attorney, of which they gave him
some of what you just talked about was after they mentioned that some of the other witnesses they'd already talked to, right? So there was a little bit of influence from law enforcement in that part of the transcript, which was very, very late in the discussion, right? You agree with that?
I agree, Your Honor, that happened before the right now without an attorney. But it was, of course, after I believe law enforcement gave clarification to him about whether or not an attorney would be coming there or whether they wanted to speak or whether they wanted to cease questioning. But going in, I believe for my third point here that I can get to is it goes against the actual text, I believe, of the Miranda opinion to require that they're going to make you call an attorney from there. The Miranda opinion itself, I believe, states that you don't have to keep an attorney at every jailhouse or police station. And here, any requirement that Davis and Miranda and Edwards require that they be more succinct with when he can get the attorney and tell him exactly the time and date that he can, that is going into asking law enforcement to give advice. And the case law is clear, and at least going back to Florida Supreme Court cases, they're not to give advice. All they are to give is an honest and straightforward answers, if you will, common sense answers. And saying he won't come here, your attorney won't come here, that is being honest and being as straightforward as you can. Your attorney's not going to come here. If this court has no other questions, I will rely on the state's briefs. And I ask that this court reverses the order and remands with directions to deny the motion to suppress.
Thank you both. It was well presented on both sides. If there is nothing further for this panel, we will officially go into recess. Thank you.
Thank you.
Thank you.